Good morning, ladies and gentlemen. I'm Stewart, Dresner. I'm chairing this session. Would people come and sit around the table? There are plenty of empty seats. There's no point in having empty seats. Come and join the top table until they're all taken. So come on down. There's 2 empty seats over here. Don't be shy.
Sorry?
The light.
Yes.
Right, very good. Thank you. There's a couple of empty seats over here. They varied the layout of this room. Last year it was all flat. 2 years before that it was like a lecture theatre. But we cope with it, however it is. There's 2 more chairs over here. Don't be shy. Come and sit over here. Okay. Well, it's 10:30, so let's begin. So I'm Stewart Dresner, Chief Executive of Privacy Laws and Business. We've been following the subject of the data protection regulation from the start. I set up the company 30 years ago, and we've been following even the original EU directive, the current directive from before that was going. So we have long experience, and there's a flyer in your bags all about what we do. So we're talking about startups here. So we're going to get some interesting ways of looking at the regulation. We're not going to try and cover everything. We're going to look specifically at the issues which affect startups. For example, we're going to look at sort of unusual angles, such as maybe data protection authorities could be enablers of the digital economy. Certainly they mostly don't have that view of themselves at the moment, but there are ways that they could make life easier for startups. So maybe data protection authorities have an economic role. So I have a limited job here, and what I'm going to first of all do is introduce my colleagues on the panel. On my right is Kaja Kallas. She's a member of the European Parliament who's been really the leading light in this subject of digital single market. She's a member of the European Parliament from Estonia and a member of the Digital Agenda Intergroup. And you've recently published a report on the digital single market strategy, I understand. Okay, and you're going to be chairing the session after I do all the introductions. Ruth Boardman is the next person along. Is one of the most famous data protection lawyers in the world, having written very extensively on this subject. A partner managing this data protection group at Bird & Bird. And also Ruth has co-written the data protection book on strategy book, published in 2012, edited the Encyclopedia of Data Protection. So you have encyclopedic knowledge, which you can bring in any time of day or night, which is very good. Next we have Lenard Koschwitz, Director of European Affairs Allied for Startups, and you joined that last year. And you told me that you have national associations from France, Germany, UK, and Italy, and a member of the US similar organization on your board. So you're plugged into startups around the world. Got 27 regional associations, of which 22 are in Europe, and broadly, you represent 10,000 startups. Yes, is all that accurate? Yes, very good. Next, along the line here, we have Catriona Meehan, Director of EU Policy and Government Relations for the Apps Developers Alliance. You have worked previously at the European Parliament and served as Chief of Staff to the member of the European Parliament on Culture and Education. And you have 200 members, and 60% of those in the EU, but your wider group are 60,000 app developers around the world, and you've got offices in US, Brussels, and London. So you're part of a centre of the ecosystem of app developers, I would say. Yes?
Yeah, our app developers are from all over the place, global, but our offices are DC, London, Brussels so far.
Right. Okay, and at the end of the line, but not the least important by any means, Antony Walker, Deputy Chief Executive of techUK, Trade Association of Tech Businesses in the UK, and your members range from large companies to small startups. And you've recently developed 8 principles to guide the digital single market. I think that's enough for me to start off with. but we thought that we would have a vote at the beginning and the end of this session to see whether your views have changed. So the title, we've got the title. We did have the title there, Will the General Data Protection Regulations Succeed in Encouraging Tech Startups? Let's have a show of hands and we'll sort of compare it now and at the end. So the question is, do you think the regulation will succeed in encouraging tech startups? Let's have a show of hands if you think yes. About one or two maybe. Those who think no. Right, clearly a majority for no, and we'll take a vote at the end and we'll see if your views have changed. Okay, and next I'm going to hand the microphone to you, Kaja, and you will talk about the link between the regulation and the digital single market.
Thank you, and very nice to see all of you here. First of all, this vote was not very encouraging, and I must say that I'm not a big fan of data protection myself. I'm a member of European Parliament since this mandate, and all the data protection rules that we currently have on the table or have been agreed have been coming from the previous mandate. So as was said in the introductory remarks that I'm the rapporteur for digital single market strategy, and we have a different view there. So the basic is building trust, yes, but as I'm a liberal, I'm not very much convinced that when we have when we impose very strict rules that it will actually encourage the trust. But probably we shouldn't go into that too much because the rules are there, and so we can't right now overlook them, but we have to see how these are implemented. As I said, digital single market strategy has a quite big emphasis on building the trust, and also from different parts of a digital market, but building trust for people to use e-commerce, to use digital services in various respects. But the main point is still to create growth and create possibilities for the companies to grow and innovate. So the biggest question we have, of course, is how the legislation has to be put in place in order to leave room for innovation, which is very important. And of course, these two things are not necessarily contradictory to each other, that innovation versus regulation, that when you have one, you don't have the other. But still, we should have this view that innovation is what we need currently. But we also have to keep in mind that Europeans have a totally different view or approach to privacy. In November, I was in United States Congress, and we had a discussion with the Congress members about the transatlantic digital economy, and there of course it was immediately after the data safe harbor decision. So there were very many questions, and I think the basic difference is that in Europe we see privacy as a fundamental right. In America there's totally different approach to this, and there's the difference. And the second point is also what we have to understand, that we can't enforce very strong rules, or maybe they are not that necessary, because in digital businesses, trust is everything. If the consumers lose trust in the business, they lose everything. So they don't really afford making this or using this data in a way that is harming their consumers, because eventually they will lead. we have said several times, and what I always emphasize is two things. One is the empowerment of consumers. If we have all these regulations in place saying that companies should do this and companies should do that, but at the same time the users, they don't care. And if we have the rules in place that ask consent for this and ask consent for that, and then it just takes down or makes the customer experience worse. Like click this, click, okay, but they don't really see what they are asking. So is it really protecting the people then? I don't know. But the other question, of course, is that maybe we shouldn't go too much into criticizing the data protection regulation as it is agreed. So we should also try to look right now how this is implemented. So this is all a question about implementation. And what is a good thing, I think, with this is that it is a regulation, not a directive, because very often when we see the European rules, then we still, even if we have a directive, it means that we have 28 sets of different implementation to it, and then we still have the fragmentation, and fragmentation is really the biggest problem of the European market. But as I said, the regulation is there, so now the question is about the implementation, and I think it's a proper time to hand over to Antony, who will talk about this.
Thank you very much. Good morning, everybody. I'm Antony Walker, Deputy CEO at techUK. As described, a technology trade association that brings together a whole range of businesses, from the very largest, who frankly have got a pretty sophisticated understanding of data protection and data protection law and how it applies to them. And I think over the last 4 years have been very active in Brussels, trying to get their message across and trying to be understood in the process of developing the new regulation. But actually 2/3 of our members are actually SMEs, and with really, I suppose, varying understandings of data protection law, varying levels of resources that they're able to put into either just compliance, but more importantly, into kind of understanding kind of the evolution and development of data protection law, and in particular understanding what the implications of this new regulation might be. And over the last couple of years, we realized that whilst the debates in Brussels on GDPR was very focused on impact and implications and views and so on for large companies, the voice of the smaller companies was kind of missing. And we also realized that when we sat down and tried to look at all the various texts that were on the table, it was really, really difficult to actually understand what the implications might be on these businesses. So we were sort of scratching our heads a little bit and said, how could we do a better job in understanding the implications and then communicating them? So what we decided to do was to invent a couple of kind of fictitious companies. And so we came up with these two companies that were sort of based on sort of real companies, but we sort of that we described. One was a kind of a new sort of fintech company that we called Lendio, that was coming to the market with new ways of providing financial services and financial products to the market, but that depended quite importantly on profiling to be able to do that. And then the other one was called Spot.Hole. I guess I probably won't have a career in kind of marketing new companies, but it was essentially it's a company that uses some Internet of Things technology, sensors in a car, to be able to identify kind of potholes in the road, and then with the ability then to send that information back to somewhere else, to somebody who could potentially come along and fill those potholes, and which has interesting environmental benefits in terms of smoother roads mean less fuel consumption and things like that. But these were two sort of small innovative companies, and we're kind of saying, okay, well, what would the implications be for these companies of the new regulation? So that's where we turned to Ruth with her encyclopedic knowledge of all things data protection, and asked her to kind of develop some case studies and some scenarios around what would happen to these companies. And then we used that information to talk to people here in Brussels and to help kind of make the case in terms of the various texts, the council text and the parliament text, and what impact that they might have. So obviously now we have the final text, and so we sort of turned to Ruth again and said, okay, what do we think the final implications could be? So I'm now going to hand over to Ruth, who's going to kind of take you through some of those conclusions, and then I think we'll have a bit of a conversation. Thank you.
Great, thanks, Antony. So the two case studies and what the regulation means for them. So Lendio, first of all. Okay, so Lendio, first of all, this is a peer-to-peer lending system. So borrowers sign up. A lot of personal data is collected for know your customer purposes, which Lendio has to do. Borrowers also sign up, and the idea is that you then match the borrower and the lender. And because this is direct, everybody wins. You get better rates, better returns. But it does depend on profiling. So if we look at the impact of the regulation, we picked up lots of points for Lendio, but in order to focus debate, we ended up focusing on two key areas. So firstly, rules on profiling. During the course of the regulation, this was a big focus because there were proposals to make some types of profiling completely illegal. The good news for Lendio, at one point we thought that it was going to have to close its doors and close business. Actually, with the final text, that's not the case. So Lendio can profile the borrowers and the lenders in order to offer its product. This will be an automated decision, which is solely taken on automated means. So there will be restrictions, and it will have to have appropriate protections in place. But that's fair enough. It is a significant decision. It will affect people. So it seems appropriate that, yes, Lendio can do this because it's a great service that people want, but it has to have appropriate checks and balances in place. So I know one of the questions we had was, on a sort of scale of 1 to 10, how difficult is this going to be? And we felt that the way the regulation came out, this was probably a 5, because it seems appropriate. Lendio can work through the requirements. It's not unduly difficult. One of the other areas that we looked at for Lendio was people and paperwork, if you like. So what are the resourcing and administrative burdens that the regulation will place on Lendio? Well, first of all, it will need a data protection officer. Although these aren't always mandatory, because Lendio will be engaging in profiling, it will be monitoring people on a large scale, it will need a DPO, but it can look externally for that, which might be helpful when it's still growing. Secondly, it will need to meet detailed record-keeping obligations. These are pretty prescriptive, so query how easy it will be for Lendio to do that, whether it will have the necessary resources to be able to do that. So on our scale of 1 to 10, of how difficult this is going to be, I would put that as a 7 maybe. I think that could be quite difficult for startups especially to get to grips with. It will also need to do a privacy impact assessment because it's engaging in automated decision taking. And I think that could be a good thing, but again, query whether Lendio will have access to the expertise it needs to do that. It's important that those checks are there, but it's not simply enough just to put burdens on new startups. We need to work out more effective ways of giving them the tools to actually meet their obligations. So that's Lendio. If we move on and look at Spot.Hole, so Spot.Hole is collecting data from your car as you drive about. This is then being used to notify the local authority of problems. So what are the problems there? One of the first areas that we looked at was notice and consent. So Spot.Hole, the idea is this is just a little fob that you plug into your car. So how is Spot.Hole going to deal with requirements to provide quite detailed information to users? How is it going to deliver a privacy policy? Here we felt the regulation was going to be quite problematic. It's one of the areas where I think there are presumptions about the kind of technology involved. There's a long list of information that has to be given to users, and it seems to anticipate that somebody's going to be on the web where you can click through to this. Where you have an Internet of Things device, that's going to be quite problematic. The very small font that no one can read, this is the list of what has to be included in a privacy policy. And the reason it's so microscopic, in order to get it on one page, that's the size I had to shrink the text to, just to get the list of the content that has to be included. So when you actually fill in those headings and explain all of that, there's going to be a lot of information there. And that's going to pose a challenge. And we've already got long terms and conditions, long privacy policies. This is a UK study that was carried out by which, the UK Consumer Association, which just looked at the length of some common terms and conditions and privacy policies and concluded that some are longer than Shakespeare plays. So I think there's a real challenge there. On a scale of 1 to 10, I would put that at an 8. I think that's going to be quite challenging. And picking up on Kaja's point, it's not necessarily going to be helpful for consumers if actually we're providing them with more and more information, which then is hard to absorb. The other thing that we focused on with Spot.Hole was sanctions. So sanctions are relevant to all organisations, but there is a risk that for a startup that they could be particularly detrimental because they wouldn't have the resources to, or the access to capital to actually withstand a large penalty. So here, fines of 4% of turnover, of course, can be imposed. There is flexibility for supervisory authorities, but at the moment, of course, there's a lack of certainty about how that will work. And the financial impact of the penalty on the organisation is not one of the factors which is specifically called out in the regulation. So we felt that that was probably unhelpful in terms of actually enabling and stimulating the digital economy. I'm going to pass back for questions now.
Okay. Okay, I have a microphone. Actually, it's very interesting. I'm also a lawyer by profession, and I used to do competition law. So the fines are quite similar, and I think probably as they are put forward, also the practice is quite similar. That they still take into account the financial impact. But I don't want to be their attorney. But I would ask so that if you have been dealing with these cases and these discussions around the data protection rules have been going on for quite some time, so how do you see the readiness of the companies to comply with the rules? So it's not like it happened overnight, but it has been in place or this debate has been going on for some time. So could you give your estimate?
So in terms of how ready companies are, I think there's some quite significant work to do. It was only in December when political agreement was reached that actually some of these key provisions were agreed. And until that point, there were very big differences in position. So you couldn't really do much to get ready. I think, Antony, do you want to comment?
Yeah, so I think there is still a huge amount of uncertainty, I think, even within the largest companies about actually what the regulation will mean in practice. And that's also particularly driven by the potential for different levels of interpretation at a national level by DPAs, and the process by which DPAs will reconcile differences of opinion. So for large organizations with a sort of sophisticated view, they see real kind of long-term uncertainty there. For small companies, I think, despite the best efforts of many of our organizations, frankly, many of them are very unaware. And I mean, an interesting thing coming back to the case study, when we looked at the Spot.Hole case study, in many ways, that company, I think, may have been quite unaware that it was even dealing with personal data, because as far as it was concerned, it was just picking up data about coming from vehicles, about bumps in the road. It didn't have any personal data. It didn't know who the driver was or anything. And their assumption was nothing to do with us. And I think there will be a lot of companies like that, particularly in the IoT space, who just don't, at this stage, realize that this regulation will apply to them.
Now I will turn to Catriona. So how do app developers see it? And one question that always is in my mind, we have this discussion going on about digital content contracts as well, and there the Commission has come with the proposal that consumer protection rules apply also when you pay with your data. And then the question arises that, like a practical question, do I have, with whom I really have the agreement? So if I purchase something, an app, I purchase it from the App Store. I don't have the agreement with the app developer. So who is really responsible for the data protection in that sense? Or if I give the consent to the App Store, does it immediately apply? Or how do you see this?
Yeah, so I think that you raise a really interesting point, and I would agree with Antony that while the larger companies also find it difficult to understand what these rules will mean for them, it's even more difficult for app developers. So when we've spoken to smaller app developers over the course of the past month, they've had so many questions because it's still very unclear. So I think what we need is a coherent and harmonized approach to this, which will entail offering clear guidelines to app developers. And when you talk about digital contracts, that's also something that we're quite concerned about, and that app developers are concerned about, in this idea of data as a currency, or using, tying data to advertisements. So I think that what we need to do is separate this idea that because an app developer is perhaps using advertising to monetize, that then they're also collecting data. Because it's not always the case, or it's sometimes used in different ways. So I think there are a lot of things here to be looked at, and obviously worked on, with this proposal when it goes to Parliament and is worked on in committee. So there's definitely scope for us to be involved in that.
Turn to Lenard now. With how do this next generation of startups really see it? And some, for example, the rapporteur for the data protection said that it could be a competitive advantage for the European companies because the people are more aware of their data and want their data to be protected. And so if it is not, then it is higher rules for European companies, then it might be a competitive advantage. So how do you comment that?
That's an excellent question, actually. So I think in principle that all the startups we spoke to are absolutely in favor of strong data protection. There's no question about it. And I think also looking at startups compared to the more traditional businesses, I think one of the key advantages is the connection and the closeness to the customer, actually. But then, and this has been mentioned before, the rules we see are to a high extent very descriptive. I don't know whether there's actually the scope or the room for that innovative principles to be transposed for data protection. And then I would also like to second what has been said before about the awareness and uncertainty, which is just, I mean, startup founders are very risk-friendly persons, but looking at the text as it stands now, it's just, there's a lot of uncertainty and a lot of risks that add up for smaller companies, unfortunately, a bit more than for larger companies that have maybe the power and the resources to deal with that kind of fragmentation. So I think a bottom line would be that it can be a competitiveness advantage, definitely. But I don't see that happening in the GDPR text as it stands, unfortunately.
I don't know who is liable for putting together this panel, because there should have been at least one person who strongly believes in the new rules in order to have a debate here, or a much vivid debate on that respect. But I will ask you additional question. What do you see that needs to be done in order to help the startups to comply with the rules? So because again, the rules are there, so we can't just bypass them. So what needs to be done to help? Absolutely,
and our approach to things is definitely trying to be optimistic and forward-looking. And as you said, the rules are there, and it has to be set as well that, although this might be a suboptimal rule set as it stands, we have a much higher degree of harmonization as compared to before, which you also mentioned earlier, Kaja, is the biggest problem in the European market, the fragmentation. So I think to a large extent we have overcome fragmentation, although in terms of one-stop shop and also flexibility the member states have in implementation, it's not quite clear for us whether it's going to be actually entirely harmonized. And then also something that I think is a very good intention of the text, but unfortunately for startup has little impact, is exemptions for small and medium enterprises, where we see at many parts in the text that the Commission and DPAs are encouraged to support, in particular, small and medium enterprises. Unfortunately, we don't see, looking at the characteristics or looking at the criteria, we don't see that startups are really considered small and medium enterprises in that text. So I think forward-looking, what has to be done, we will definitely seek a dialogue with the DPAs and try to elaborate and establish a way on good working practices. I think for a startup, it would be ideal to have anything that comes close to a standard concept that can be adopted and taken up before going to business. Because, well, it was mentioned before that several administrative steps are actually have to be taken before processing can be done in a lawful manner. And if we look at an impact assessment, possible consultation, the involvement of a DPO, this is just very detrimental to the actually way of that startups do business. So the idea of a lean startup where a product is being launched very quickly and a feedback is collected and the product is also renewed and relaunched and in a short time frame, is just very hard to realize if there's long periods and long consultations that would even apply for a beta version that is meant to be tested.
Catriona and Antony both wanted to comment, so please.
Oh, yeah,
yes.
I just wanted to add to that. I mean, I agree with what Lenard's saying, and there is still much uncertainty, and it can come across as quite critical. And I just wanted to pick up on your point, Kaja, that everything we're saying is quite negative. However, I would like to add that it is, on one hand, good that, at least from an app developer perspective, that we are thinking about privacy and data protection and how to, reinstall trust in consumers. So I'd just like to say that that's a good positive point of the GDPR.
That's it.
Yeah, I mean, so look, we have a text. We've got a sort of 2-year period before its implementation. I think if we can keep one thing at the forefront of our minds is in the implementation of all this, how are we going to make this as simple and clear for the consumer as we possibly can? You know, we've had all of the debates, we've had the philosophical debates and so on. We're now at the implementation stage. How do we make this easy? And I think, and that's where I think national DPAs have got an incredibly important role to play, both in terms of being clear and consistent in terms of their approach to implementation, working very, very hard with their partners across other member states to quickly resolve differences of opinion, because, you know, startup businesses move fast. They can't sit around for 2 years with, you know, with huge uncertainty about what the rules might be. But also, very importantly, I think it's essential now that that DPAs recognize the sort of economic significance of their work. You know, they're absolutely vital to regulating a core part of Europe's growing economy, and its future for job growth and so on. And so I think DPAs must bear that in mind when they're thinking about the implementation, and recognize that they have an economic responsibility in all of this now. To make sure that we do have a growing and digital economy in Europe. Because for digital businesses, data protection is one of the most fundamental kind of cornerstones of the regulatory frameworks that they have to depend upon. So I think that kind of recognition of the economic significance of all this is terribly important.
Of course, it's very, very complicated to make the data protection authorities cooperate and really do the decisions in the short term. And of course, it is because the cases are complicated as well, and we have a huge problem in Europe with cooperation between the member states. So let's see how this goes. And of course, I totally agree with your point that also the authorities must understand that this is hindering the economy if it doesn't go too fast. But on the other hand, we also have to keep in mind the user or the citizen or the customer. So I have a question for all panelists. What is the position of the users here, and what could be done by the companies to empower their users so that they would trust their data with them? So, Antony.
Yeah. So I mean, I'll come back to Ruth's points in terms of kind of terms and conditions. The regulation kind of adds to the list of things that businesses must provide information about, and for many companies that just means a longer T's and C's. I don't think that's particularly helpful to anybody. I don't think it informs the consumer in a useful way. So we're going to have to think about how can we come up with novel ways and new ways of informing the consumer. And I think DPAs can help give confidence to companies and support them in developing those kind of, new and novel ways. And recognize there are lots of ways you can signal and to the consumer that isn't just about kind of terms and conditions. And also DPAs should be playing a kind of educational role as well, helping consumers and citizens understand a little bit more about data, so that, the two can meet halfway, I think.
So I think from an app developer perspective, something that the Apps Alliance has worked on with one of our member companies in the US, Intuit, was a short form privacy notice. It's open source that app developers can download build into their apps, which helps inform consumers what data is being collected and how it's being used. So I think if we could get to a point where we do have more certainty with the GDPR, that would be a great thing to build here in Europe in order to inform consumers and let them know exactly what's going on with their data.
Yeah, I think that is sounds like a great idea, definitely. I would also like to sign up to what Antony said about more innovative ways to information, and I think there's really a pool of startups and great ideas that can be tapped and looked into. First of all, I guess, however, we need really legal certainty. So a startup has to know, if I use this, I'm on the safe side. I don't have to worry anymore whether maybe in a different market, in a different jurisdiction, I might be challenged on that. So I think, as I said before, anything that goes towards more standardized elements that can be used, and of course. And I think there is a mention of symbols and other ways of informing the user. Anything like that can, of course, made best use of the good ideas coming from startups.
Okay. One thing that we've not mentioned on the panel has been certification and seals and standards. I think that's one of the things that the regulation actually does really well in this space. It doesn't provide the mechanisms yet, but the seed is there to incentivize people to do that. And I think that is one area which, if it takes off, can be a real win-win. It will be a good way for providing certainty for consumers who won't have to read Hamlet when they're looking at the terms and conditions and privacy policy. They can just check that the organisation has the appropriate seal or certification. And it will then help startups because you will have a toolkit, a way of knowing what to do to be compliant. So I think that's a really important part to focus on.
Yeah, so the panel have come up with various good ideas. We've come up with an idea for the using privacy seals, just mentioned now, short-form privacy notices, but maybe, and we know that the data protection authorities are, obviously they are regulators, but maybe industry associations could take the initiative to come up with, using perhaps these case studies, to come up with a model privacy impact assessment, because they are discussed as sort of concepts. But if using these case studies, maybe the tech associations could say, here is a 2-page privacy impact assessment, or 3 pages, but not 30 pages, which then could be used as a model and then present to the new European Data Protection Board, saying this is what we think would work for small startups, and we ask that you have a comment, rather than waiting for them to tell you what to do. So that's my suggestion. Yeah, we're all nodding, good. So I think at this point we'd like to open up to the audience. We only have 1 hour for this, so let's see how many people want to raise a point, either ask a question. We've got 1 here. Got anyone else? Okay, well, we'll start with you. Could you, a couple of people here. So could you give your name loudly and your organisation, and then we can take your point. Sorry, Ministry of the Interior from which country? Germany, okay, right. Microphone here.
Thank you. I'm a little bit surprised that you are still not that pessimistic about the result of the GDPR. Just 2 points which were missing in the discussion right now. Did you do, question to Ruth and Antony, did you do more case studies or was it just those 2? Because I think in the big data context, the GDPR has a much worse outcome when you think about 2 rules in the regulation. One is the rule about further processing data, and the other one is the missing rule about publicly available data. Further processing is regulated in a way that it is said further processing is allowed if purpose 2 is compatible with purpose 1. And we do not know how compatibility is interpreted by the data protection authorities. In Germany, the data protection authorities interpret it in a very, very strict way. That would mean most big data applications where in the beginning you do not know what your purpose is would be not allowed at all. And the connection between purpose 1 and purpose 2, of course, is sometimes very, very far away. So if there is no link, it's not allowed at all.
So is your point that you think there should be a link between first purposes and then further processing?
No, the regulation demands a link.
Yes.
And if there is no link, it's not allowed.
Right.
So you do not have a legal basis for processing. And if you have a legal purpose, you still have to inform the data subject. So if you have millions of data, for example, publicly available data, in social media monitoring, you have to inform every single data subject that you are now processing your data and that you further processing the data.
You're saying your main point is this is a burden, this is a...
No, it's not a burden, it's not allowed at all.
Not allowed, right.
Big data, for example, social media
you're asking
analysis is not allowed at all. So my question would be, have you maybe done other case studies? Those two seem to me a little bit classic applications, traditional applications. More advanced applications might not be allowed at all.
So I think your question is, are there any other case studies which bring in this point about further processing?
Yeah, and my question would be, from the German point of view, how is this further processing topic debated in other member states?
Okay.
So just very quickly, we didn't do any additional case studies, but certainly in the work that we did, we absolutely focused on the issue of further processing and how problematic this could be. Well, I think I'd also add, some of the issues around kind of joint liability, I think, are really kind of problematic as well for many firms as well. So, I mean, I suppose I've been sitting here slightly trying to be as optimistic as I can, really, because the regulation is there and it is what it is. As I said, I think there is still a lot that we don't really understand about what its consequences might be, whether intended or unintended. And I mean, the real challenge for Europe will be actually in terms of we will see what it does to innovation in Europe versus the rest of the world. And I think one thing I would absolutely say is if we do start to see any signs of significant innovations being accelerated outside of Europe but not happening in Europe, I think we will have to look again at this because I think the implications of that could be quite serious. Of course. Keeping in mind absolutely the importance and primacy of data protection, but we also must have jobs for our citizens as well as privacy.
Yeah. Okay.
I quickly wanted to add to that, if possible. Indeed, we tried also in respect of the time not to open a long list and be too pessimistic about things, because in the end we will have to deal with it in somehow. Now, well. In some way, saying that one particularity about startups is that they probably, within their first 5 years, they ask themselves several times, where will I establish my business, or whether I want to move my business. So something that is really a difference between established companies or SMEs to startups is that they are quite mobile. And from our perspective, of course, we could have opened a long list of this makes it harder, this makes it harder, this makes it harder. Unfortunately, always comparing to other jurisdictions. I think a fair facet of this is really that there's probably not one killer in this regulation, but it's probably many small things that rather increase risk and uncertainty. And if you are about to launch your business, and if you are about to make this decision whether to launch here or there, this is probably going to have an impact.
Okay, I think we should move on to the next point, because someone else had a question. I think, yes, please. Give your name and organisation. Just speak. just speak into the microphone and we'll see what happens. Well, let's just speak. I know you have my microphone. Somebody coming over to help him. It certainly was working a moment ago. Or use mine. Just pass it.
So, hi everyone. My name is Magda Piech. I represent Polish employers organization. companies of all sizes. We don't have so many startups, I must say. But just to add to the discussion, we made a similar study to yours, but based on, let's say, traditional companies.
Okay, another microphone's coming along.
So we made a similar study with lawyers, and we simply asked them how much you would charge for advice on data on the regulation, as it was suggested by the European Parliament. So definitely more expensive than the council version. And it turned out that for compliance itself, it would be 9 times more than what it was in Poland up to now. So just to add to the debate. And that's why I didn't like all the information requirements, explicit consent, data, actually maybe impact assessment, not so bad, but prior consultation, it adds a lot of burden. But what I actually liked about the proposal was data protection by design and by default, especially by design, because I assume that it should make people who create apps or new products to think about privacy, just to think, right? And my question is, to what extent do you think these two principles can be implemented and taken into account while designing new products? And then, let's say, how can it be implemented into entire process of data protection, processing?
Okay, so the question is, how can privacy by design and privacy by default be included in new products and services, new apps? Who would like to answer?
Yes, I think privacy by design is extremely important, and I absolutely agree with you. I mean, one area where I think is, in terms of technology innovation, I think is obviously really interesting. Maybe a little bit overhyped at the moment, but in terms of kind of blockchain technology and distributed ledger, in particular for where data is being used really for authentication. At the moment, we exchange a lot of personal data just to authenticate, and where you've got distributed ledger, kind of blockchain technology, you've got the potential to massively reduce the amount of data that you have to move around. And therefore data minimization, I think is very important. So I think that's one example of one area, in particular where it's data being used for authentication purposes, where I think technology innovation should mean that we have to use much less personal data for authentication.
Okay.
Yeah, no, I think that's a great point. I just like to pick up on your point that the compliance, legal advice for compliance would cost a lot more, and that could potentially and probably be burdensome on many companies, especially the smaller ones and app developers. I think that it's crucial in this that we don't make it harder for small businesses, we don't add extra burden, because at least app developers, and I'd say any company, wants to comply with legislation. They need it to be clear in order to do so.
Okay.
Just, I wanted to comment that as I was a partner in 2 law firms, and then I would say that, of course, price of the lawyers should not be the indicator, because if you ask the lawyers, of course they say that we charge a lot, but then always come new lawyers. You know how much they educate the lawyers, so there are very many, and there is competition, and competition always brings down the prices. So I wouldn't rely on this as an evidence.
Okay, well, clearly legal advice is expensive, but very different.
Good value, though.
So I think you had a question over here, didn't you? Yes. So can we have the microphone over here, please? I think it's the last question. Could you give your name and organisation, please?
Hello, I'm Pernille Tranberg. I am representing a think do tank called Data Ethics, which is much more than just complying to the regulation, because I think that you will see a huge consumer trend where people will ask for this. They want privacy, or they want to control their own data.
Which country are you from?
I'm from Denmark. Unfortunately, right. I'm sorry about that.
Why unfortunately? Everyone loves
I'm not very proud of that at the moment. I'm writing a book about this, and I'm collecting cases, and I actually do have some really good examples of startups using privacy as a competitive advantage. But I want to hear you, if you have any. Mm-hmm. Do you have any good case stories about that, or do you want to swap some ideas? I need more cases from you, because we need role models. I also want we need to exchange role models and show that to startups, because it's going to be a competitive advantage, just like with the environment 20, 30 years ago.
Okay, so you have some examples of privacy competitive advantage. That sounds wonderful.
So I guess I don't have any concrete example now from the top of my head, but I'm sure I'd be happy to connect you to our, through our network and to look for things in particular where I guess we can be helpful. But yes, definitely, absolutely, it can be a competitive advantage, and I try to be as clear as possible about that. But then, really, I think it's about leaving that room for innovation, like giving the market and new companies really the ability, to use this as an advantage. So. And I think the idea underlying here is something that is mentioned a lot around Brussels, is trying to make future-proof regulation or legislation. And I think it's really not the subject whether we're going to talk about privacy, or about environment, or about other innovative ways of creating a benefit for the customer, but really about leaving room here to innovate.
Okay, Kaja's got a concluding remarks.
No, I just actually wanted to say that about role models. I can't bring you example from the company, but I can bring you example from a country where I come from. It is Estonia. So we try to do this in the public administration, that the user is owner of his or her own data. So that we have all this e-government and all the digital services, public services. So this is the main principle as it is done.
Can I just to a couple of things? I think we're going to see quite a lot of kind of data vault type businesses coming to the market. I think lots of people have been waiting for the regulation to be completed. So I think we'll see things there. Actually, that sort of technology, some of it has been around for quite a long time. It's just been waiting for its kind of market opportunity. There's a very interesting thing. Check out the HI project in the UK. Very innovative new approach to kind of flipping, in a way, some of the way in which the consumer kind of controls access to their own data and so on in a very simple kind of automated way. I absolutely agree with you. I think there will be innovation, but I think we can't rely on all consumers being kind of motivated to take all of those steps. Yeah. So yeah, I agree. So that's why coming back to this, transparency and clarity for the consumer, I think, is very important. We've got to make it as simple as possible for people.
Okay, I think we have to. We've only got 1 or 2 minutes left, so we have to. I have my job to try and sum up. We've talked about that there should be, whatever the regulation is, there should be still room for innovation. We don't want to. We want to be an enabler for companies, and we need to educate data protection authorities to move into a new era of recognizing their responsible regulation, but they can become an economic enabler if they get themselves organized, and that we, or those representing tech companies, can develop the case studies, which have been sort of a very good starting point, but with model short privacy policies, and perhaps model short privacy impact assessments. These can be helpful in bringing the subject to the attention and the particular issues of startups to the attention of the new European Data Protection Board, the organisation which will take over from the Article 29 Data Protection Working Parties. The new secretariat for that is the European Data Protection Supervisor's Office. So they are alert. They have an ethics initiative which is being discussed at this conference, and they're very alert to take on new ideas. So although there is still some uncertainty to what the regulation means in practice, the tech companies and their associations can help the process. I was certainly very impressed by the last person who asked the question about the case studies where companies have used privacy competitive advantage. My company used this title. I selected that title for one of our conferences about 15 years ago, Privacy as a Competitive Advantage. It was an aspiration then, and we couldn't prove it very well, but we think that's what it ought to be. So can you come and see me later and tell me about your stories, and we can perhaps publish them in our publications and cover them in future issues. So I hope that in 1 hour we've done the most we possibly could to ventilate the question, to discuss the issue, and I said at the end we would have a vote. We remember at the beginning the question was, will the general data protection regulation succeed in encouraging tech startups? We know at the beginning that very few people thought so, but let's just stand up and put up hands. If you think the regulation will encourage tech startups now, we've had the discussion, hands up those who think yes. A little bit more optimism, I think, maybe two or three times, still a small number, but a few more. What about those who think no? It's more even. I think it's pretty even. Don't you think so? So I think we have had some... Maybe, yes. Oh, maybe. Let's hands up for maybe. Yes. All right. But I think it's much more even. We have had a shift. So thank you to all of the panel for very, very precise and concise and brief. And thank you for coming along. And let's keep the discussion going. And I'd like to see the lady there from Denmark to get more of those examples, and we'll publish some of those good news stories. So, thank you.